Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
Thank you, Michael, for the introduction here. Don, again, welcome to the show.
Thank you.
And I'm excited about today. We're going to talk about the key points when people list their house.
All right.
But before we get into that, just give us a little background about yourself for the viewers that maybe don't know who you are.
Well, I'm an attorney. I graduated from law school in 1982, have a degree in taxation, been practicing over 30 years. I've been a member of Ross, Lanier & Dyfek, a law firm, for approximately 20 years, have my own title company, Ross Title and Escrow, and I'm one of the shareholders at Downing Fry Realty. I'm the attorney for that company as well.
And your location of your office?
599 9th Street North, which is right on 41. As I tell all my male clients, it's across from Pastrami Dance. Every guy in the world seems to know where that is.
We see you there all the time.
Yeah, right. Don't tell my wife.
But give us a little background on your team that you have there, because I think it's a pretty impressive team.
Oh, thank you. We have 8 people. They've been with me ranging from 2 to 27 years. 4 of them are actually related. They're from the Midwest. Good work ethic, what I look for, a good work ethic, intelligent, and character. Character is important, somebody I can trust, because I'm here with you right now, so I have to be able to trust these ladies. And they've all been trained by the same person, my office manager and myself, and we have streamlined it in the way that seems to be most effective.
It certainly is. I know with every transaction I do with you is very smooth. So, well, we're here today to talk about contracts when you list a house.
Sure.
And, we have quite a few pages here, but we're going to highlight some of the key points. And,
okay.
And the key points that we're going to be is the mistakes people make or
okay.
a realtor might make in filling out the contract. So maybe we start with the owner's name.
Well, probably one of the most common mistakes is having the wrong person on the listing agreement. There's representations in the listing agreement, and I have here, I don't know, probably 10 different forms that relate to the listing agreement, but the listing agreement itself, realtor goes and meets with the owner, the ostensible owner, and asks them to fill it out. And many, many, many times, in fact, I had it happen today, I get not all the owners. Probably the most common one would be, and I'll use myself as an example, my wife and I own our home together, Don and Coletta Ross, husband and wife. Mm-hmm. If it's simply in my wife's name, tendency would be that she would be put down as the owner.
Right.
Florida, though, has a part of our Constitution that prohibits my lovely wife from selling the home or mortgaging the home without my consent, or if it were my name alone, without her consent. The reason being, way back in the day, there was a concern about the welfare for families and children. They didn't want one spouse to pass away and the other spouse to find out after the death that, oh my word, this $500,000 home is mortgaged to the hilt, and or my spouse left it to so-and-so, they owe gamblers or whatever. So it's strictly to protect women and children. The one I had today, the listing agreement was signed by someone using a power of attorney from Virginia. Uh-huh. And this is something that for any owner, if you're using a power of attorney to list the property, please, please, please get a copy of that to whatever lawyer or title company you're using, so they can look at it and see if it's sufficient to sign a deed. Mm-hmm. Okay, because the power of attorney has to be executed with the same formalities that would be for a deed.
Right.
Realtor is not necessarily going to know that. That's a law school issue. Certainly somebody from Virginia is not going to know what the law is in Florida,
Right.
unless they took the bar in Florida. So, you know, if you have a power of attorney, and that's happening right now in my office, you get it to the closer, the attorney quickly, and again, if you have a trust or whatever, you check to see if is it Homestead? Is that your home? If so, your spouse needs to join no matter whose name it's in.
Okay.
If somebody's died, all the kids have to sign, if it's Homestead.
So Homestead plays a
Huge role.
huge role. in
Huge
it.
role. And again, people get angry when I tell them that their spouse needs to sign, but when I explain that it was initially to protect women and children, they understand a little better.
So to make it simple here is that if I'm sitting down with a client and they're married, obviously, in that the wife is, that the house is just in the wife's name, the husband has to sign it also.
Yes.
Okay.
And again, the wife will probably object. In my experience, the
Right.
wife objects, and it's Article 10,
Right.
Section 4 of the Florida Constitution. It protects families.
Right. and
That's the point.
How about if somebody's been divorced or anything like that, then you would want a copy of the...
You would, you know, as quickly as possible.
Right.
I mean, you're taking the listing, you're going to spend money, you're going to put time
That's
into
right.
it. It'd be a tragedy to get to closing and find out you need the signature of somebody else.
That's
you know, whether
right.
it's a trust or an estate. They'll have an estate from another state, the executor from another state signing, and they don't realize you have to actually have a probate down here as well.
Right.
So you get it to your closer as quickly as possible. And again, I've had people ask, well, should the realtor have known? Well, no, they didn't go to law school. I mean,
Right.
I've gone through the realtor classes. My dad's a realtor, my son's a realtor, so I sat through those classes with them. And it's way beyond what a realtor is trained to do. I mean, your job is to produce a ready, willing, and able buyer, or to market the property, not to be an attorney.
That's right. That's right. And let's just move on a little bit here. I think we beat that one enough.
Is it dead?
It's dead. It's dead. To come into life again.
Okay, all right.
So how about the deed or the legal description? I'm still on the first page there.
Okay.
Maybe I just highlighted that, or you know, the property ID number to make sure that those are correct, right?
This actually is a good one. What comes up quite often, they'll have the wrong legal description. They'll have the wrong storage or boat dock or slip number.
Right.
The condominiums will change the numbers internally.
Right.
And again, you want, you know, to explain to the homeowner that
Right.
you need the accurate information. Do you have a deed? Do you have any of your closing documents when you acquired this property, so that you have some point of reference to plug in the right information? There's on line 28 where if there's any personal property being conveyed, furniture, and this is a big issue. Furniture
right.
is big on so many levels. We could talk the whole show about it, but for purposes of this, what I get most often is we go to closing, we have the sales contract, and the buyer's under the impression that they're entitled to the interior furniture. And I ask, well, why? He said, well, it's in the listing agreement. And I said, well, okay, what was the list price?
Right.
You know, $1 million. And this contract is $800,000. Are you going to pay $1 million? No. And I'm trying to, in a sarcastic
That's
way,
right.
make the point that this is what they're offering to sell.
Right.
You made an offer to buy. You didn't list in your sales contract the furniture,
Right.
which you don't want to do until you talk to your lender, if you have one.
That's right.
You know, 'cause so you just because it's in the listing agreement doesn't mean it automatically flows into the sales contract. So the furniture is tricky. You want to put it in there if it's going to be part of the package, and the realtor and the seller both need to be very clear in the sales contract what furniture is being conveyed. I get more fights over that than probably anything.
Right. And, you know, just talk to us a little bit about what would be included in a normal listing. Would a TV that's attached to the wall be included, or stereo equipment, or or should they
Well,
do
fixtures,
that as?
fixtures is another legal term, and it's typically anything that's nailed, screwed, or glued to the wall.
Right.
Now, most TVs have, they have a bracket that's been screwed into the wall, and the TV detaches, so the TV is not part of it. Now, the public, most of them, thank goodness, are not attorneys.
Right.
Who would want that many attorneys in one place? So my advice to agents generally is, even though you think the contract covers it, you can put it in the sales contract itself, you can put it in the listing agreement, that the TV attached to the bracket or whatever it is included as part of the transaction, even though it might be a fixture.
Right.
Why? Because communication between the parties is critical.
It is, right.
I mean, they didn't go to law school, they're not an expert like you in real estate. You want them to have a clear understanding about what the listing, these 5 pages, covers, and you don't want to have to get a lawyer on the phone to explain to them what fixture means.
That's right. That's right.
They'd rather have it twice than have it once and them not quite get it.
In the responsibility of a broker in this contract, what would that entail?
Well, that's on the second page.
That's right.
And again, as the attorney for Downing Fry, you get occasionally you might get somebody who they met another realtor at a cocktail party, or they have a cousin who's a realtor and they want to terminate their listing with whoever. The broker's obligation is one, to become informed about the property, and then there's a fine line with that. I get people who go almost too far. Do I need to read all the condo documents, Don? Well, you don't give legal advice, but you can't do your job effectively if you don't know what the pet restrictions and the rental restrictions and what kind of vehicles can be there. I mean, enough in order to get them to sign the agreement and have their review period where if there's anything more substantial, the lawyer can look at it and they can terminate. So the broker is obligated to become informed. They want to get a good seller's disclosure out of the seller, and sellers resist this. They don't like it for some reason. It puts them out of their way. I really don't understand why. I can assure the public, though, that it protects the seller.
Right.
It absolutely, without a doubt, protects the seller. If you disclose something up front and the buyer signs this seller's disclosure document, they're taking title subject to that non-conforming item if something's broken, unless they put it back in the sales contract. And this is NABOR contract. We get more situations after a closing where a disgruntled buyer is calling the realtor and the seller, and they want money because the ice maker's broken or the fan isn't properly balanced, or I had one today where the air handler was working fine and 9 months later died, and now he realizes he has to get a whole new system.
Right.
He didn't realize that. So a real thorough seller's disclosure will avoid a lot of aggravation for the seller.
That's right.
Absolutely. And it also benefits the realtor too, because they come after the realtor and the seller, for sure. Plus it helps the buyer know what they're buying.
Exactly.
I mean, full disclosure builds trust with the buyer. People are excited when they make their offer, so you can disclose pretty much everything in most cases, and psychologically I think the buyers are more apt to trust that seller if they're just open and honest.
That's right. I agree with you. Don, we're going to take a little short break, and we're going to be right back in 1 minute. Thank you.
When picking a realtor, don't just pick anyone. Pick someone with experience. Pick someone with a proven track record. Pick a realtor like Jim York from Downing Fry Realty, the #1 brokerage with the most real estate transactions in the area.
My husband and I had very specific ideas about what we wanted in our new home. Jim York was able to help us find the home that was ideal for us.
With over 20 years of real estate experience in Southwest Florida, Jim York has negotiated over $200 million in sales contracts. Selecting the right realtor is a critical decision that can earn you thousands when selling or save you thousands when buying.
Jim also helped us with a mortgage lender and a good real estate attorney. He went that extra mile, and his experience says it all.
Call Jim York for a no-obligation meeting at 239-273-6727 or visit his website, www.naplesyorkrealestate.com.
Welcome back, Don. Let's move on here and talk about sellers' obligations.
Sure,
We've been talking about realtor, the broker's obligations. So let's just touch base on seller obligations.
No problem. If I could preface that, when you asked me to come on the show, I mean, I'm used to the legal issues when it hits the fan.
That's right.
Okay, so what I did to be prepared, I actually do homework for your show. Thank you very much, by the way. Is I went to Pat Patoki at Downing Fry, who teaches a series of classes on the various materials.
And she's our corporate trainer.
Oh,
there, right.
the lady is absolutely brilliant. But I said, Pat, I'm an attorney. I'm not an agent.
Right.
So teach this to me as though I were an agent. And so, I have my 15 forms that are semi-related, different situations come in, but so this came from her, but the seller's obligations, and I do see this quite a bit, and this is a biggie, is to refer all inquiries to the broker.
Right.
If the seller bumps into anybody who says, I might want to buy that, a relative, another broker, whoever, they are obligated to relay that to the broker. To quote Pat, this is a bilateral agreement. And when she said bilateral, I almost fell down because that's law school, and I never heard a non-lawyer use that phrase in my life. But it means both sides have to do something.
Right.
The broker has certain obligations and promises that were made, and the seller has certain duties. So the seller can't just say, I quit, I'm out, I want to terminate the agreement, unless there's something in there that says so.
That's right.
But they have to refer all inquiries. They have to give access to the property to the broker. The broker can go in there and take photos, put it on the website, display it, share it with cooperating brokers. Stay in touch with each other. Comply with applicable statutory and regulatory disclosure requirements. Now we're back to our disclosure statement again. Now the required disclosure is the latent material defects that we've talked about on other shows, things that are hidden that materially affect the value of the property. It's got to be something significant, and that goes back to a Florida Supreme Court case in 1985. But our seller's disclosure goes above and beyond that, because in the real world, when a buyer moves in, they're indignant that the air handler went 9 months later, or the ice maker is broken in $1 million condo, or that there might be an open permit on a 19-year-old set of shutters. So you disclose, you disclose, you disclose, and this requires the seller to do so. And they have to give you copies of any leases or anything relating to the property. And then when you go to the next page, and this is becoming more and more important, the top of page 3, give copies of your existing owner's title insurance policy, which a lot of people probably don't know what it is, but it's part of the packet you get after you close with the recorded deed, and any survey you might have. Now why? Most sellers don't want to do that. It might be back home somewhere. They are not sure. They don't want to take a few hours and go look for it. I get it, but it's becoming more and more of an issue in doing closings. If you have a prior survey, if it's less than a certain number of years old, most underwriters will allow you to use that. If there's an affidavit signed by the seller saying there's been no additional work since that survey date, and I can look at that survey and say fine, and it complies with the setback requirements and the easements, there's no encroachments, it's fine, we can close. But when the seller doesn't go looking, then I have to order another one, and I'm getting, frequent errors. There are so many different, over the years that a development might have existed, there might be multiple monuments in a corner, which is a marking they put in the soil from which they measure the length of one side. And you might go from, in the very beginning, having a concrete monument that's 6 inches under sand, and now you've got an unnumbered iron rod, and you have an encroachment, which is a real pain to resolve. It is a major headache for the seller. It could jeopardize the deal. The title policy, it might help the buyer save some money. If the buyer goes and uses a different underwriter and they come up with some off-the-wall exception, you can go back to the first underwriter and say, you know, what the heck is this? And they might have an explanation, or they might be required by the treaty among the various underwriters to indemnify the second title underwriter for that particular issue. So both those things are hugely helpful to the seller. I see it more and more often in what I do. Our business is just becoming more complicated. So they got to get somebody who's been doing it for a while, or is experienced or knowledgeable, a quick learner,
Right.
Or they're going to have problems.
They're going to have problems.
They're going to have problems.
You're exactly right. And we did touch a base a little bit on seller's disclosure. That's a form that you know, that's so many pages that they have to fill out. By our company, Downing Fry, they're required to fill it out, even though legally by the state you're not required to fill it out.
Well, again, the case is Johnson v. Davis. It was and the facts might be a little off here, but it was approximately $100,000 house, and the roof was shot. It was leaking. It was not the rainy season, and the seller didn't tell the buyer that the roof needed to be replaced. It was approximately $20,000, which would affect the value of our home, of that sales price. And up to that point, the law in this state had been buyer beware, caveat emptor. It was the Latin phrase. And the Supreme Court said, you know, it's gotten to the point where on residential transactions, if the seller knows of a latent material defect, material is something that would change the value, they have to tell the buyer. They have to. Now, most real estate brokerage firms require something more comprehensive. Why? Because you'll get a deluge of unhappy buyers calling on every little thing, and who needs to hire lawyers to argue over whether something's material?
Well, that's right.
I mean, it's just a nightmare. It's a nightmare for the seller, it's a nightmare for the agent, it's a nightmare for the brokerage company, and you know, the example, well, I use many examples, but my daughter lives in Baltimore. She was selling a car that we got her when she was a junior in high school, and she had a loose leaf binder of every repair bill she ever did. And she asked me, Dad, you know, what do I do with this? And I said, you give it to the buyer. Now, the buyer was a married couple buying the car for their 16-year-old daughter, just like I did when I bought it for her. I said, this man happened to be a member of a Volkswagen club. It was a Jetta. And I said, Aaron, if you give him the binder, she went to school with your son, by the way, but if you give him the binder, they will trust you. You're telling them everything. It makes the deal go 1,000 times smoother. Nobody's trying to get clever here. And it did. It went very smoothly. She got exactly what she asked. And in real estate, it's pretty much the same. It's human nature. If you're open and honest and straight with someone on the other side, you're going to have fewer issues. You just are.
Okay, and then another important part is the disclosures on if you have a CDD or homeowner's disclosure or condo disclosure. So maybe you want to touch a little bit on that.
Sure.
I know there's some forms here that they have to fill out.
Well, the CDD, there's a provision in the sales contract, and apparently when she teaches her class, she recommends that you leave a copy of the sales contract as well with the owner, so that when you bring in that initial offer, it's not a total shock. I mean, there's going to be a price, and they're going to have to, it probably won't be what they're asking for. Maybe they might get multiple offers, whatever the situation. But the more you can do to make people comfortable,
certainly.
Here's what you're going to probably receive, something on this form. Read it and call me if you have questions. The easier it's going to be for you to present the offer, and they'll be focusing on the price or the financing terms or whatever it is. And part of that is CDD MSTU, which I think we covered on our last show.
We did.
You get the Community Development District, which oftentimes has a payoff. And the contract, you can check off whether the seller is going to pay it off or not, or if the buyer is going to assume it. And the MSTU is for the ongoing maintenance of the development. There is no payoff, it's just an annual fee, and they want you to disclose that to the buyer. I recommend to agents, have the owner fill it out. If the owner has any questions whatsoever, contact your management company, because guess what, in these materials, we have all the management companies and their phone numbers and their email addresses, so all our agents get this, so they can give it to the owner and say, call them, find out, and then you can fill it out.
That's right.
Makes a huge difference. The HOA, same difference. Under, and I think we talked about this as well.
That's right.
It's 10 paragraphs. Paragraph 8 says the statements contained in this disclosure are summary in nature, and as a prospective purchaser, you should refer to the covenants in the association governing documents. So they're warning the prospective buyer, before you sign this, you might want to look at any restrictive covenants, use restrictions there might be in the restrictive covenants. Do they regulate what kind of car you drive, or whether you can put a portable basketball hoop at the end of the driveway, or a sign in your lawn, and things of that sort? Can you plant anything in the yard without getting permission from the architectural committee? And you get the owner to fill it out, and they'll say, I don't know, I'm not sure, I think. Well, again, you have your list here of all the management companies, and please call and then fill it out. That's required by law. If you don't get it signed at the same time as a sales contract, the buyers have 3 days to cancel after you finally do give it to them.
Right.
So that's a huge issue.
It's a huge issue. Well, Don, we're going to take another little short break, and we're going to come right back, and we're going to get a question from our website.
Okay, great. Thanks.
Thank you very much.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Don, we have a question from our website, and it's, as I remember what they wrote in was, when a listing is expired or it's been terminated or withdrawn, and afterwards somebody comes and they're interested in buying the property and goes to the seller to buy the property, what is the obligations of the seller to pay the original broker a commission?
Well, again, the listing agreement's 5 pages.
Right.
And you want your broker to explain it to you thoroughly. The contract's 10 pages. This is half the length of the contract.
Which is good.
And this is really a separate contract, because they both have obligations. But if it's somebody the broker has been working with during the term of the listing, and the owner has not signed a new listing agreement with another broker, they have an obligation to pay the first broker if it's within a certain time period. And it's in line 123 here. Which does not have any default language, which goes back to, I probably forgot to say this, you don't want to leave blanks in this form. You absolutely do not want to leave blanks. There is not default language to many items, and this is one of them. So if you're the realtor, you want to know that if you've been working with somebody, like somebody walked in the day before a listing's ready to expire, and they're going to make an offer, and you don't have this filled out, you're going to have a lawsuit.
Right.
The owner wants a specific date in here. They want to know what this means, so they're not theoretically obligated to 2 different
commissions.
For 2 different commissions, or they want to know when it's safe to sell it to somebody else, if they want to sell it to one of their kids or a family member or a friend. So it's very important for both parties to fully understand what they're signing. I mean, there are no stupid questions, as they say, just the ones you don't ask. This is important. It involves a significant asset, usually an expensive asset. And I would read it carefully. I would make sure you understand it as best you can. And if you have any questions, you have your management company that can help you with some of these things. And that disclosure again. The survey, the prior policy, people don't want to look. I get it. Human nature is to do as little as possible, but this will save you a lot of grief down the road.
And they should, you know, I've always said that you should have having your team on board when you sign this, meaning
absolutely.
that, you know, have attorney or whoever's going to do your closing
Sure.
for you, because they can help you also. And I'm sure if somebody wanted to call you on the phone, you'd certainly take and answer their questions.
I do it all day long.
I know you do.
I do it all day long, and I get a lot of these forms that have been marked up by New York lawyers, and what does this mean, Don?
Right.
So I'm happy to help anybody with this. I don't ask, you know, who they come from or if they're an existing client.
That's
I just
right.
try to
I
help.
know you've been very helpful.
Thank you.
Well, thank you, Don, for coming on, and
You're
I
welcome.
know our viewers have learned a lot, and I know there's a lot more we could have gone over, but our time is running out here. So, again, thank you very much.